welcome to the Analyst dated 18th October 2023 by Vajiram and Ravi, wherein we'll be looking into important current affairs articles from both the Hindu as well as Indian Express. And the handout of this very discussion is available in the description below. Let's have a look over the table of content. So firstly, we are going to look into the issue of legalization of same-sex marriage because the Supreme Court has given its verdict in this regard. Then we'll be looking into Speaker's partition role. We'll try to understand what is anti-defection law, what are the functions of the Speaker, and what are the issues when it comes to the partisan role of the Speaker. Then we'll be looking into Ethics Committee of the Parliament. Then we'll be looking into India's space station. And lastly, we'll be looking into red tide, which is an environmental issue. So let's look into our first topic, which pertains to same-sex marriages. Now this topic pertains to this very aspect of our GS Paper 2 syllabus. Let's try and understand the context. So the context is a 5-judge bench headed by the CJI by 3:2 ratio has declined to recognize same-sex marriages in India. Now the first thing that we need to understand with regard to this article is what is same-sex marriage? So it is basically a union between two individuals who belong to same gender. It is a legal union between two individuals who belong to same gender. And when I say legalization of same-sex marriage, it implies that such homosexual couples should be provided with the rights and protections which are available to heterosexual couples as well. Now, let's look into Special Marriage Act, which I'll be mentioning time and again in this very discussion. When it comes to registration of marriages, it could be done under your personal laws like your Hindu Marriage Act, like your Muslim Marriage Act, and it could also be registered under Special Marriage Act. Now, when it comes to Special Marriage Act, it enabled the intercaste and interreligious couples to solemnize their marriage under this Special Marriage Act. So, under the Special Marriage Act, they do not have to undergo religious conversion in order to solemnize their marriage. Okay, in order to get their marriage registered, they do not have to change their religion. Now, time and again we will be referring to this very term civil union, which is under the Special Marriage Act. Now, when it comes to civil union, it is legally recognized union between two individuals regardless of their caste, their religion or nationality. It is without going through rituals and customs. But when it comes to marriage, rituals, customs play a very prominent role here. But when it comes to civil union, it is a legal agreement between two individuals, and this is done without going through traditional rituals and customs. It resembles a marriage. So, when you enter into a civil union, when two individuals enter into civil union, they get associated benefits which are associated with marriage, like you get property rights, you get inheritance right, adoption right, etc. But what is the difference between civil union and marriage then? First difference, as I have told you, when it comes to civil union, traditional rituals, custom and religion have no role to play. Because when it comes to civil union under the Special Marriage Act, here it is sanctioned by the state and not by the religion. But when it comes to marriages, here traditional rituals and customs play a very prominent role, and religion also plays a very prominent role. When it comes to civil union, it is available in different countries for same-sex marriages only. But when it comes to marriage, it is available to both homosexual couples as well as heterosexual couples. And lastly, when it comes to civil union, it would be recognized in certain states only, not in all the states. But when it comes to marriage, it is globally recognized. Now, let's look into the arguments in favor of legalization of same-sex marriage. First is, in order to provide equality, we need to legalize same-sex marriage. Because Article 14 and 15 prohibits discrimination on the basis of sex. And the Supreme Court in Navtej Singh Zohar versus Union of India case 2018 has stated that sex include sexual orientation as well. So, we are denying homosexual couples the right to marry and right to legalize their marriage based on their sexual orientation. This is violative of Article 14 and 15. Then, in order to ensure right to privacy also, we should move in this direction. We know that when it comes to Puttaswamy judgment, the Supreme Court has stated that right to privacy forms an integral part of your Article 21 right to life and personal liberty. And right to privacy basically implies that a person would be having the right to make choices with regard to his or her own body, and when it comes to making choice with regard to intimate relations. So in the direction of right to privacy also, we should move in the direction of legalization of same-sex marriage. Then, in order to provide legal protections to the same-sex couples, because currently the same-sex couples, they can enter into partnerships, but they are not provided with the rights and protection which are available to heterosexual couples. Like, they do not get property inheritance right, adoption rights, and the right to take decisions whenever there is a medical health emergency with respect to their partners. So in order to provide them with the legal protection, we should legalize same-sex marriage. Then, in order to promote their social acceptance, because when it comes to LGBT community, they time and again witness social stigma. Why? Because when it comes to Indian society, we are guided by heteronormativity. When it comes to Indian society, we consider marriage is something which is only between man and woman. It cannot be between individuals belonging to same gender. And that is the reason time and again the homosexual couples witness social stigma. For example, Leela and Urmila, who were police women, when they got married in 1987, they were suspended from their jobs and they were put behind the bars. So in order to, promote social acceptance of this LGBT community, we need to move in the direction of legalization of same-sex marriage in order to address the social stigma that they are witnessing currently. And if you look at the global practice, 34 countries have already recognized same-sex marriage. First was Netherlands in this regard. And lastly, in order to enlarge human rights also, we should move in the direction of legalization of same-sex marriage. What are human rights? These are the rights that you enjoy by virtue of being a human. And in this regard, United Nations has pointed out the importance of rights with regard to LGBTQ community, and it also includes the right to marry a person of one's own choice. Now, let's look into the arguments which are against same-sex marriages. First is, as I told you, when it comes to Indian society, the religious definition of marriage is, it is between man and woman. We are guided by heteronormativity. The petitioners have argued that the court should do gender neutral interpretation of Special Marriage Act 1954. But this Special Marriage Act was basically enacted by the parliament to do away with the limitations that the intercaste and interfaith couples were witnessing when it comes to their respective personal religious laws. Because when they solemnize their marriages under Special Marriage Act, they do not have to undergo religious conversions. It did not pertain to creating a new institution of marriage itself. If we go for legalization of same-sex marriage, by doing gender neutral interpretation of this act, what we are trying to create is, we are trying to create a new institution of marriage itself, which is not something which this act intended to do. Then, the state have all the legitimate interest to regulate the marriage. The state would be regulating what should be your minimum age of marriage, how many marriage you can undergo, and whom you should marry. Because when it comes to marriage, it has a public element attached to it. So in this regard, the state have all the legitimate interest to regulate the aspects with regard to marriage. Then, when we talk about right to privacy, you have right to privacy with regard to, this aspect that with whom you want to enter into sexual intercourse with whom you want to develop a sexual relationship. Till that, right to privacy is applicable. But when you start demanding that right to privacy extend to marriage, what you are trying to say is, marriage is also a private affair. But that is not so. Marriage has public element. And that is the reason the state is not moving in the direction of legalization of same-sex marriages. Because when it comes to entering into consensual sexual relationships, building sexual partnership, till that, right to privacy is fine. But we cannot extend it to marriage because it has public element involved with it. Then, there are issues with regard to interpreting Special Marriage Act as well. Because under this act, wife has been given certain rights. Okay, like the wife would be having the same domicile as her husband, and one of the grounds of divorce is if the husband is guilty of rape. Now, when it comes to same-sex marriage, who would be considered as wife under the Special Marriage Act? That is another question. Then experts have pointed out that for better development of the children, we should not move in the direction of legalization of same-sex marriage. In this regard, National Commission for Protection of Child Rights has pointed out that if you move in the direction of legalization of same-sex marriage, you are actually violating Juvenile Justice Act 2015, which do not allow a single man to adopt a female girl child. So if you look at the adoption laws in India, they do not allow for adoption of children by same-sex couples. This is in interest of the children, because when it comes to Indian society, it is again guided by heteronormativity. Then, in Navteej Singh Zohar versus Union of India case, the Supreme Court decriminalized homosexuality. Fine. But in this very judgment, the Supreme Court did not directed that civil rights would also be extended to LGBT community. Civil rights as in they would be having property rights, inheritance right, adoption right, etc. But that was not something which the Supreme Court stated in this very case. And lastly, as we know that we are guided by heteronormativity, and according to the religious definition of marriage, it is only a union between man and woman. So if you move in the direction of legalization of same-sex marriage, it would be leading to social unrest. Now let's look into the key takeaways of Supreme Court's verdict. First and foremost, the Supreme Court stated that right to marry could not be declared as a fundamental right, because the petitioners have argued that right to marry a person of one's own choice should be considered as a fundamental right. But the Supreme Court stated that no, right to marry is not a fundamental right, because when it comes to marriage, its fundamental importance to an individual is it is based on your personal preference and it gives you a social status. Now, the Supreme Court argued that just because marriage is having certain fundamental importance to an individual and it enjoys popular acceptance also, it is accepted by the society, it is not a valid ground to make right to marry a fundamental right. In US courts, right to marry has been, time and again arguments have been given in the US courts that right to marry should be a fundamental right. Why? Because it enables the individual to enjoy happiness. It is fundamental for an individual to enjoy the happiness. But the Supreme Court in case of India argued that no, this is not a justified or a valid ground to declare right to marry a fundamental right. Then the petitioners have argued that the court should interpret Special Marriage Act in a gender neutral manner. What do I mean by that? They stated that the word marriage should be interpreted as between spouses and not between men and women. And the petitioners also argued that the court should struck down the gender restrictive provisions of Special Marriage Act. But the court in this regard argued that if we strike down gender restrictive provisions with regard to Special Marriage Act, we would be jeopardizing the legal framework which is there in place for interfaith and intercaste couples to solemnize their marriage. And if we strike down the gender restrictive provisions or we interpret this very act in a gender neutral manner, we would be amounting to judicial lawmaking, which would be violative of your doctrine of separation of power, according to which one organ is not supposed to perform the functions of the another organ and it is not supposed to interfere in the functioning of the another organ as well. So, in order to avoid judicial legislation, the Supreme Court stated that we cannot tweak Special Marriage Act. Then, it declined to allow civil unions for non-heterosexual couples. Civil unions is something which is provided in Special Marriage Act. Okay, it is a legal union between two individuals which more or less resembles like marriage, as we have discussed right now. Now, in this regard, the minority view was the right to enter into civil union is a part of your freedom of speech and expression, part of your right to life, and if we are not allowing the same-sex couples to enter into a civil union, or we are not allowing civil unions when it comes to same-sex marriage, what we are doing is we are discriminating on the basis of sexual orientations. And this is violative of your Article 15 of the Indian Constitution, which prohibits discrimination based on sex. And as we discussed previously, the Supreme Court has interpreted that sex also includes sexual orientations. But the majority view was, we cannot allow civil unions among the same-sex couples. This should be looked into by the legislature and not by the courts. Then when it comes to rights like to open joint bank account, adoption right, inheritance, property right, the right to take decisions whenever there is a medical health emergency with regard to your partner. In this regard, the Supreme Court stated that this aspect would be looked into by a high-level cabinet committee and not by the courts. And lastly, when it comes to adoption rights, the adoption guidelines, according to CARA, which looks into the adoption aspect of the children, is like that you can jointly adopt a child if you are married and your married life has been stable for at least 2 years. So then you can jointly adopt a child. Otherwise, you can adopt a child as a single parent or individually. In this regard, single male cannot adopt a female child. But when it comes to single female, she can adopt a child of any gender. Now, the LGBT community argued that you are not allowing us a civil union to be recognized legally. So, we cannot jointly adopt a child according to the adoption guidelines which are issued by CARA. So, now in this regard, the minority view was also accepting this fact that yes, when it comes to the adoption guidelines, it is somewhere discriminatory towards the LGBT community. But the majority view was largely in alignment with the CARA guidelines when it comes to adoption of children. Because the majority opinion was, if we make requisite changes when it comes to joint adoption of a particular child, which is based on your marital status, it could lead to disastrous impacts on the Indian society. And that needs to be looked into by the legislatures and the executive, not the courts. So these were the major takeaways from the Supreme Court verdict. Going forward, it is up to the legislature to look into this very matter, that whether legalization of same-sex marriage should be done or not, because the court have left this issue to be decided by the legislatures. But overall, in order to address the social stigma which is time and again being witnessed by the LGBT community, we need to move in the direction of educating our society, making them aware with regard to the rights of this community. And the legislature, if it wants to move in the direction of legalization of same-sex marriage, it should effectively address the concerns of the opponents who are opposed to this very idea of legalization of same-sex marriage. That is all that we have to make note of from this very topic. Let's move to the next one. Now, this next topic relates to partisan role of the speaker. This topic relates to this very aspect of our GS paper 2 syllabus. We also have a previous year question in this regard. So after listening to this very discussion, please try and attempt this question. What is the context? So the context is, Supreme Court has given the last chance to Maharashtra Assembly Speaker that you set a timeline for anti-defection proceedings against the Chief Minister Eknath Shinde and other MLAs. Why? Because the elections are around the corner. And this is one of the reasons that Speaker of the Maharashtra Assembly is delaying to take a decision when it comes to anti-defection proceedings against the CM and other MLAs. Previously, the Supreme Court in this regard has given the direction to the Maharashtra Assembly Speaker that you please come up with a reasonable timeline, it could be around 2 months, to take a decision with regard to anti-defection proceedings. Now, in this regard, the first thing that we need to understand is, what are these anti-defection provisions? These were inserted into the Indian Constitution through 52nd Constitutional Amendment Act 1985, which is referred to as 10th schedule of the Indian Constitution. This basically looks into the disqualification of a member of parliament, MLA, etc. on the ground of defection. Now let's look into the provisions for different types of member of parliament that are there. If a member of parliament belongs to any political party on whose ticket he has got elected to the house, then he would be disqualified from being a member of the house if he voluntarily gives up his membership of such a political party, or if he votes or abstains from voting in such house contrary to any direction issued by his political party. That means contrary to the direction issued by the whip. So every political party has a whip whose major role is to ensure the attendance of the members of that particular party and to ensure that the political party gets the requisite support of its member in favor of or in against of a particular issue. And if that member of parliament who belongs to a particular political party, if he is voting or abstaining from voting without obtaining prior permission of such political party, in this scenario, he would be disqualified from being a member of the house. When it comes to independent members who get elected to the house without the ticket from any particular political party, if they join any particular political party after they become the member of the house, then they would be disqualified on being a member of the house. When it comes to nominated members, 10th schedule would be applicable if they join any political party after the expiry of 6 months from the date he or she takes his seat in the house. So that means in the meanwhile, between this 6 months from the time they become a member of the house, in this 6-month period, they can join any political party. But once the 6-month period get expired, they are not allowed to join any particular political party. And if they do so, they would be disqualified for being a member of the house. But there are certain exemptions when it comes to anti-defection provisions. If the members are going out from a particular political party on account of merger of that party with another party, and this exemption would be applicable only when the merger takes place when 2/3 of the members of the party have agreed to such a merger. The exceptions are also available for presiding officer. So if a member got elected to the post of speaker, deputy speaker, deputy chairman when it comes to Rajya Sabha, then in this background, if they give up the membership of their particular political party, 10th schedule would not be applicable on them. And once they cease to be speaker or deputy speaker, if they again join the political party, then also anti-defection law would not be applicable on them. This is done in order to make sure that when they are acting as the presiding officers of the house, they act in an independent and impartial manner. Now, what are the advantages of this anti-defection provisions? First, it gave constitutional recognition to political party. Then, it ensures political stability by addressing defections among the member of parliament. Then, what are the disadvantages when it comes to anti-defection provisions? First disadvantage is, it reduces the member of parliament or an MLA to be a mere delegate of that particular political party instead of being a true representative of the voters. Because in the name of anti-defection provisions, what we are witnessing is the party is enforcing party discipline and it is curbing dissent. This is one major disadvantage. Second disadvantage being, as has been pointed out by the previous speakers of Lok Sabha, Ravi and Shivraj Patil, that it is impossible to make sure that the speaker takes decision when it comes to anti-defection law in an impartial manner. And time and again we witness delay when it comes to taking decisions with regard to anti-defection provisions by the presiding officers. Because when it comes to anti-defection provisions, the decision has to be taken by the presiding officer of the concerned house. And in this regard, in Kihoto Holohan case, the Supreme Court has pointed out that when the presiding officer is deciding with regard to disqualification under the 10th schedule, it is acting as a tribunal. So, the decision of the presiding officers would be subject to judicial review if we found that the presiding officer has acted on the grounds of malafide. Now, let's look into the functions which the speaker performs. So, his major role is to maintain order and decorum in the house so that effective debate and discussions could be carried out at the floor of the house. He or she is the final interpreter of the provisions of the constitution, rules of procedure, conduct of business of Lok Sabha and parliamentary precedents which relates to functioning of the house. He does not get the right to vote in the first instance, he gets casting vote. So, he is allowed to cast a vote only when there is a deadlock or when there is a tie in votes. Then, he presides over the joint sitting of the two houses whenever there is a deadlock between the two houses with regard to a particular bill. He certifies whether a bill is a money bill or not. And lastly, as we discussed right now, he decides the questions on disqualification under the 10th schedule. Okay, one major issue when it comes to 10th schedule is no time limit has been prescribed. That is one of the major reasons why we witness delay when it comes to taking decision on disqualification under the 10th schedule by the presiding officers. Now, let's look into the provisions which are there in the Indian Constitution to make sure that the speaker act in an independent and impartial manner. First is he or she has been provided with security of tenure. So, he can be removed only when a resolution is supported by at least 50 members. So, this resolution, if it enjoys the support of at least 50 members, then only such a resolution would be accepted by the house and discussion with regard to removal of the speaker could begin in the house. And he or she would be removed only when such a resolution is passed by effective majority, not by simple majority, which implies that 50% of the members present and voting. But effective majority basically implies that majority of the then members of the house. So, you get effective majority by reducing the vacant seats, okay, from the total strength of the house. And whatever remainder that you get, 50% of that would be termed as effective majority. So, the speaker could be removed only through a resolution which is passed by effective majority and not by simple majority. Then his salaries and allowances are charged on the consolidated fund of India. So, his salaries and allowances are not subject to the annual vote of the parliament. It could only be discussed, but it could not be voted upon. Then, his work can't be discussed except on a substantive motion, when a motion is there in the house with regard to removal of the speaker. Then, the powers to regulate procedures or conducting business, maintaining order in the house of the speaker is not subject to jurisdiction of any court according to Article 122 Clause 2 of the Indian Constitution. And as we discussed, the speaker do not vote in first instance, he get a casting vote whenever there is a deadlock. This is again done in order to make sure that the speaker act in an impartial manner. And as we discussed, exemptions have been provided to the speaker that if he get elected to the post of the speaker, he can resign from his particular political party, and once he ceases to be a speaker, he can again join the political party. In that regard, the anti-defection law would not be applicable on him. All this has been done to make sure that the speaker act in an independent and impartial manner. But what we are witnessing right now is, speaker is acting in a partisan manner. This we can very well understand with regard to the delay when it comes to taking decisions under the anti-defection law. As we discussed, one of the issue, no timeline has been prescribed in the Indian Constitution. And time and again, what we are witnessing with regard to Maharashtra State Legislative Assembly, this is the scenario with the other states as well, that the speaker delay taking decisions with regard to defection under the anti-defection law, and it keeps on delaying till the fresh elections are going to be organized. Okay. Then criticisms were levied against the speaker as he certified Aadhaar bill as the money bill. Then what we are witnessing is the speaker is not giving due time to the member of parliament who belong to opposition political party so that they can raise their concerns with regard to important issues like discussing the Pegasus issue, discussing the Citizenship Amendment Act, discussing the Adani Hindenburg report. And what we are witnessing on account of this is frequent disruptions in the parliament, which is in turn having a negative impact when it comes to parliamentary productivity and efficiency. Then Speaker is time and again resorting to guillotine closure motions. So what are closure motions? So the closure motion basically implies that let's cut short the debate on this very matter and put the matter to vote. When it comes to guillotine closure motion, it implies that the undiscussed provisions of the bill are also put to vote along with the discussed provisions of the bill on account of lack of time. So what we are witnessing is 18% of the bill which were introduced and passed in the same session during the 15th Lok Sabha. And this number has increased to 33% and 69% in 16th and 17th Lok Sabha respectively. And what we are witnessing is average time which is being spent discussing a bill has dropped from 213 minutes in 2019 to 85 minutes in 2021. Lastly, less number of bills are being referred to parliamentary committees, because in this regard, the speaker has to take a call that whether to refer a particular bill to a parliamentary committee or not. And what we are witnessing in this regard is, in 14th and 15th Lok Sabha, around 60% and 71% of the bills were being referred to parliamentary committees. So it ensured the legislatures to exercise control and scrutiny with regard to the bills which are being introduced in the parliament. But what we are witnessing that in the 16th and 17th Lok Sabha, the number of bills which are being referred to the parliamentary committees have reduced to 25% and 13% respectively. So all these instances point out that the speaker is acting in a partisan manner. The last thing that we need to understand with regard to this article is what needs to be done in this background then. We can adopt the practice which is prevalent in UK, that is once a speaker, always a speaker. So once a person gets elected to the post of the speaker, he has to formally resign from his particular political party. And when it comes to the constituency of speaker, it remains unchallenged in the upcoming elections. This goes a long way in ensuring that the speaker acts in an independent and impartial manner, because then in the upcoming election, he do not have to rely on the party tickets. Then we can come up with a cooling off period after a person ceases to be a speaker, okay? Between when he ceases to be a speaker and the period after which he can again become a member of the house, or again he can become a member of the political party. Then in Aadhaar judgment, the minority view pointed out that there should be judicial scrutiny with regard to the speaker's power to certify a bill as a money bill. This was highlighted by Justice Chandrachud. Because when the speaker do so, especially with regard to Aadhaar bill, the experts pointed out that this was being done in order to circumvent the scrutiny of the Rajya Sabha. Because when we talk about money bill, we know that Rajya Sabha has very limited power with regard to money bill. It has to give its recommendation within 14 days, and those recommendations are not binding on the Lok Sabha. So, in this behalf, the minority judgment which was given by Chandrachud in Aadhaar judgment pointed out that we need to bring in the judicial scrutiny with regard to certification of bills as money bills by the speaker. Because if the speaker is misusing this power, what he is actually doing is he is violating bicameralism, which is one of the part of the basic structure doctrine. Then, in order to curb the partisan role of the speaker when it comes to allocating the time with regard to what all agenda the house has to discuss on a particular day, we can adopt the concept of opposition days, which is prevalent in case of UK. Wherein if the parliament is supposed to meet for 100 days in a particular year, for 20 days, the opposition political party would be getting the power to decide the agenda which the house is going to look into. So we can also adopt this concept of opposition days in order to make sure that the opposition political parties get requisite amount of time to raise their concerns with regard to any important public issue that is there. And this would go a long way in addressing the issue of disruptions of the parliament. When it comes to anti-defection law, the second ARC report has pointed out that with regard to 10th schedule also, the decision should be taken by the president or the governor with respect to state legislatures, and they are supposed to take the decision based on the advice of or the recommendation of Election Commission. The way they do with regard to the disqualifications which are mentioned under the Indian Constitution under RPA Act, Representation of People's Act. Then we need to set up a timeline or time limit within which the speaker or the presiding officer should decide on the disqualification proceeding under the 10th schedule. Because the judicial scrutiny could be there only when the presiding officer has taken a call in this regard. Before that, the judiciary cannot take any decision, it cannot do anything until and unless the presiding officers had decided with regard to the disqualification proceeding under the 10th schedule. Because if they do so, they would be violating the separation of power. So, time and again in this regard, the court has pointed out that we need to come up with a time limit to decide the petitions for disqualification under the 10th schedule. For example, in the recent Maharashtra State Legislative Assembly also, the Supreme Court has pointed out that within 2 months, the speaker should take a call with regard to disqualification proceedings. And lastly, we should allow expression of dissent, because this is one of the major causes of defections also. As we discussed right now, when it comes to anti-defection law, one of its major drawback is it curbs dissent in the name of party discipline. So, as has been pointed out by Dinesh Goswami Committee on Electoral Reforms and Law Commission 170th report, that this anti-defection law should be applicable when it comes to crucial matters only, like confidence and no confidence motion, seeking the vote when it comes to money bill, etc. In other aspect, please let the Member of Parliaments and the MLAs raise their dissent with regard to a matter of public importance. That is all that we have to make note of from this very topic. Let's move to the next one. Now, this next topic relates to Ethics Committee, and this topic pertains to this very aspect of your GS Paper 2 syllabus. The context is Lok Sabha Speaker has referred the complaint against Moitra to Ethics Committee because another BJP MP has levied charge against Moitra that she has taken bribes to ask queries in the House. The political matter is not something we are going to discuss into. What we are going to look into is Ethics Committee, which is relevant from our UPSC perspective. And the BJP MP has also levied charges against Moitra that she has done breach of privilege and contempt of House. Let's understand what are these two terms. Time and again we use these terms interchangeably, but they have their different interpretations. When it comes to breach of privilege, it refers to such act which disregard or attacks any privilege, rights and immunity which are either enjoyed by an MP individually or the privileges which are enjoyed by the House collectively. Now, individual privileges, example being an MP get freedom of speech in the House. So, he is not liable to any proceeding in any court with regard to whatever he is saying in the House, with regard to whatever vote he is giving in the House. When it comes to collective privileges, the House is having the right that it can stop the press from publishing a true report with regard to secret sitting of the houses. Okay? So, if any act is disregarding or attacking any individual privilege or the privileges which are enjoyed by the House collectively, then that act would be termed as breach of privilege. But when it comes to contempt of House, it has a wider implication. It refers to those acts which obstruct the House or its members in performance of their functions and which directly or indirectly reduces the dignity, authority or honor of the House. Now, an example which is a contempt of House but not a breach of privilege being disobedience to a legitimate order of the House. Now, such an act would be lowering down the dignity, authority and honor of the House. Now, the next thing that we need to understand is what are parliamentary committees. So, when it comes to Indian Constitution, it makes mention of parliamentary committees, but there is no specific constitutional article which, deals with the composition, the functioning of the parliamentary committees. So, parliamentary committees are basically those which are elected by the House or whose members are nominated by the presiding officers. When it comes to elected by the House, we have Public Accounts Committee, members nominated by the presiding officers, you have departmental related standing committees. They work under the direction of chairman or the speaker. They present their report to speaker or chairman, and they have a secretariat which is provided by Lok Sabha or Rajya Sabha. So when it comes to consultative committees, they are not parliamentary committees because they do not meet these 4 conditions which are mentioned here. Because when it comes to consultative committees, the membership in consultative committees is voluntary and they are, regulated by the Ministry of Parliamentary Affairs and not by the presiding officers. Then, what is this ethics committee? So when it comes to Rajya Sabha, it has constituted its ethics committee in 1997. Lok Sabha had its ethics committee from 2000. So its basic function is to enforce the code of conduct for the members. So it looks into misconduct and, give requisite recommendation in that regard. So it maintains discipline and decorum in the House. When it comes to Rajya Sabha has a code of conduct for its members since 2005. But Lok Sabha Ethics Committee has yet not formulated a code of conduct for its members. When it comes to Rajya Sabha, it has a 14-point code of conduct for its members, which basically says that private interest should be subordinate to the public duty and none of the member should accept or should expect any fee, remuneration for whatever thing they are saying in the House, for whatever vote they are giving at the floor of the House. And it also points out that the MPs should not do any such act which brings disrespect to the House. That is all that we have to make note of from this very topic. Let's move to the next one. This next topic relates to India's space station and this topic pertains to this very aspect of our prelim syllabus. What is the context? So the context is, Honorable Prime Minister has directed Department of Space to aim at setting up Bharatiya Antariksh Station by 2035. Now the first thing that we need to understand is, what is a space station? So it is a habitable spacecraft which has crew members, okay, and it is usually in the lower Earth orbit. And if India would be having its space station, then it would be entering into the league of USA, Russia and China. China has its own space station, that is Tango. Then when it comes to USA and Russia, they are a part of International Space Station. What is International Space Station? It is the single largest man-made structure which is in the lower Earth orbit. It is at around 400 km above the Earth. When it comes to lower Earth orbit, it is very close to the Earth and it can range from 160 km to 1000 km. Then it is a joint project of NASA, Roscosmos, Japan Space Agency, European Space Agency and Canada Space Agency. And it was launched in 1998. It has been working since 1998 and it is expected to operate till 2030. It circles the Earth in roughly 93 minutes and it completes 15.5 orbits per day. It hosted till now more than 3,000 research and education investigation in the domain of biology, physics, microgravity, etc. Then, ISRO has previously also given certain details with regard to India's space station. It has stated that it would be much smaller in size as compared to the International Space Station. Its mass would be around 20 tons and it would be used for microgravity experiments. What is microgravity? Wherein we feel that the objects are weightless because the gravity is quite low. And these microgravity experiments could be carried out in India's space station, which cannot be carried out on the Earth on account of, high gravity of the Earth at the Earth's surface. And preliminary plan is to accommodate astronauts up to 15 to 20 days in space. It would be basically an extension of Gaganyaan mission. The orbit of this India space station would be at around altitude of around 400 km above the Earth. And ISRO is working on space docking experiment, that is SpaceX, which is very crucial for making space station functional. What is the space docking experiment? It is a technology which enables us to transfer humans from one spacecraft to another. What is the significance? Why India, is planning to come up with its own space station? It would enable us to collect scientific data, okay, in various domains. It would enable us to carry out scientific studies for a greater number of time, for greater number of days. Because when it comes to Gaganyaan, it would be sending a crew mission to the space only for 5 to 7 days. But if we will be having our own space station, then we can carry out these scientific studies, microgravity experiments over a longer period of time. And it would also enable us to do deep space exploration. It would enable us to gather scientific data with regard to different galaxies, with regard to biology, what is the impact of space when the human, stay in space for a longer period of time, etc. And if we, are successful in coming up with our own space station, India would be entering into the league of nations like China, Russia and USA. That is all that we have to make note of from this very topic. Let's move to the last topic. Let's look into our last topic that relates to red tide. This topic pertains to this very aspect of our prelim syllabus. The context being, experts have pointed out that the sea in Puducherry has turned red due to abundance or bloom of algae. As a result of there being more nutrients in the water, this allows the algae to proliferate into red tide. Let's understand what is this harmful algal blooms. So when colonies of algae grow out of control and produce toxic or harmful effects on people, fish and marine life, then it is referred to be as harmful algal blooms. People normally call it as red tides, but scientists prefer to call it as harmful algal blooms. One of the best example of harmful algal blooms is witnessed in USA every summer along the Florida Gulf Coast, which is caused by a special species of algae known as Carenia brevis. When it comes to harmful algal blooms in freshwater lakes and reservoirs, these are mostly caused on account of blue-green algae, which is also known as cyanobacteria. And this is on account of agriculture and urban runoff. Why? Because we use chemical fertilizers, nitrogen-based, phosphorus-based fertilizers in the agriculture. And when it comes to urban runoff, how it leads to nutrient pollution in the water bodies? Because phosphates is used as a binding material in the detergents. And the industrial waste also consists of such nutrients. What are the causes? So, major causes eutrophication, which again refers to algal blooms on account of excess nutrient supply, that is nitrogen and phosphorus. So when there is excess nutrient supply, then it leads to eutrophication, that is algal bloom. So another cause is temperature. So during summer, we usually witness red tide. Why? Because during summers, the temperature is around 23 to 24 degrees Celsius. And during summer, as the oxygen supply gets reduced, so a lot of marine animals die, and this, dead marine animals are used as nutrients by the algae. This again leads to algal blooms. Then turbidity also determines that whether there will be algal bloom or not. Turbidity basically refers to the suspended particles or organic matter in the water bodies. So when the turbidity is low, it basically, enables the algae to receive adequate amount of sunlight. Then what are the impacts? So dangerous toxins are released by the harmful algal blooms, which could result in respiratory health issues among the human beings, and it is also harmful for the marine organisms. It could lead to creation of dead zones. Why? Because when there is algal bloom, what happens? As and when the algae would get die. So these dead algae are decomposed by bacteria. Now as the algal bloom is there, so the bacteria would also be needing more amount of oxygen in order to decompose these excess algae. This would lead to increased biological oxygen demand, and this would reduce the supply of oxygen to other marine organisms. What is call it as dead zone? Because it leads to the creation of hypoxic conditions. That is, the oxygen supply comes down to a great extent. Then it impacts aquatic organisms and plant because it reduces the supply of sunlight and oxygen to other marine organisms and plant. It is also going to raise the treatment of cost of drinking water as excess nutrients are there in the water. Then how we can mitigate the risk from harmful algal blooms? So we can ensure tertiary treatment of the sewage water before it is being discharged into the water bodies. We can go for nitrogen testing and modeling, which would enable us to understand that what is the amount of chemical fertilizer which a particular soil requires. So this would reduce the nutrient pollution in the water on account of agriculture runoff. And lastly, we can promote organic farming, which would go a long way in reducing the nutrient pollution in the waters on account of agriculture runoff. And we should also reduce the use of phosphates as a binding material in the detergent. When it comes to India, we have Algal Bloom Information Service and ISRO's OceanSat-2 satellite, which was launched in 2009, which provides timely information with regard to harmful algal blooms. That is all that we have to make note of from today's analyst. Thank you for listening to this very discussion and all the very best for your preparation.